just got the green light. There were all kinds of technical difficulties. Apologies for that, but thanks a lot for our technicians for ironing it out. So everything works now. And a cordial welcome from my part, to this ÖFG Peaceful Change lecture series. And I'm very happy to welcome Professor Charlotte Koo to the lecture series today. She will talk on the US and the International Court of Justice, and in more metaphorical terms about unfulfilled promises and a lot of years of unfulfilled promises. And the lecture today actually is quite important for our project. So we have with the Austrian Research Association, we have had this project for over 6 years about peaceful change in international relations. And obviously, one big hope was that international courts would help to bring about peaceful change. But that probably requires states to take these courts seriously. And that probably applies even more so to great powers. So that's why I think this is a very important talk. I just want to introduce Professor Koo to you very briefly. She's Professor of Law at the Texas A&M University, there at the School of Law. She's taught at many other prestigious places as well. So I'm just going to mention a few of them: the University of Illinois, University of Cambridge, Johns Hopkins, University of Virginia, and so on and so forth. She publishes a lot, so most of the CV that I have in my hands here are publications. And what makes her particularly interesting from an international relations point of view — I'm not an international lawyer, just international relations — is that she oftentimes crisscrosses between international relations and international law. Making, therefore, especially the evolution of international law intelligible to people like me as well. And thanks a lot for that. So please join me in welcoming Professor Koo.
Well, thank you so much for the invitation, Markus, into this wonderful program that you have here. And now I know of your project, which makes this even more salient for my understanding of your interests. And for those of you who have come this evening, it is indeed a great honor for me to address this audience. And if I may say, at a time when there are many questions about engagements with international institutions, not only in the United States, but if I may say, even in countries in Europe. So it is a moment where some stock taking is perhaps appropriate, and there is often some usefulness, in my view, to go back in time to look a little bit at history to see how we got to where we presently are, for two reasons. One is it might inform the understanding of why things look the way they do right now within institutions, between the relationships of members of those institutions and the institutions. The other is, should we decide that we want to start everything all over again, you have to start from someplace, and sometimes the baseline will be that which has come before, even if you decide to start something completely new. So I think useful to just remind where things have come before. So the century that I speak of is actually from about 1920 to about 2018. So 1920 was when the Permanent Court of International Justice was established by the League of Nations. And 2018 was when, during the first Trump administration, the United States withdrew basically from the jurisdiction of the International Court of Justice. The other thing is, for those of you who are here who may be thinking we're talking about the International Criminal Court, indeed I am not. I'm talking about the International Court of Justice, although the story of how the International Criminal Court got set up and the U.S. role in that bears some resemblance. There are some parallels with the ICJ story. So to the extent that, that is of interest to you, if you listen with that in mind, if you go back to look at the history of the setting up of the ICC, you will find, certain parallels. The talk comes from a chapter that I wrote for a book collection at some point. How does this work? Nope. Okay. Well, in any event, I don't know how this is advancing, or it does not. Usually, yeah. This seems to be plugged in, so I don't know. Well,
without, if push comes to shove.
Yeah.
Because otherwise we'd have.
So, in any case, it comes from a book chapter, which I think the PowerPoint somehow can be made available to you. It was intended for your viewing, so you can get the citation from that. So, in 2018. Because of a case that Iran brought against the United States for violations of treaty obligations under the Treaty of Friendship that the U.S. and Iran had, the U.S. felt that the court was not going to move in the friendly direction towards the United States, and therefore decided to withdraw its acceptance of the jurisdiction of the court. In that case, under the terms of a treaty. So this was the Treaty of Friendship between the U.S. and Iran. A day after that announcement was made, the National Security Advisor of the United States announced that if there were any other treaties under which the United States would be obliged to go before the International Court of Justice, it was also withdrawing its agreement to any of those. So basically taking itself out of the ICJ for any of the specific treaty obligations. In 1984, the United States had already removed itself from the general jurisdiction for general acceptance of the jurisdiction of the court following the Nicaragua war. Nicaragua sued the United States for intervention in Nicaragua. And the concern there was that, again, this was not going to be something that the United States felt was a proceeding it wanted to take part in. So it failed to appear and then withdrew its consent from the court. So that's kind of the end of the story. So what I want to do is take you to the beginning of the story, because the beginning of the story was that the entire idea of an international court was very much promoted by the Secretary of State under Theodore Roosevelt, a man called Elihu Root. Okay, so that's the, okay.
It's working.
It
You
is.
just have to find the page. I'm not sure.
Okay. All right, so that's
thank you.
Thank you. So that's the withdrawal. Okay. So, okay, here actually, this photo is the last sitting of the Permanent Court. The Permanent Court, founded in 1920, actually became the International Court of Justice. They just sort of, it sat in the morning as the PCIJ, in the afternoon they became the ICJ. And, all of the records and everything were transferred. So the International Court of Justice basically has pretty much an uninterrupted span of its jurisprudence. The court today, that is a photo of the present court. There are 14 judges, 15 are provided for. You have judges from Uganda, from Slovakia, France, Somalia, China, etc. There are 1, 2, 3 women on the court. By custom and practice, the 5 permanent members of the UN Security Council are usually represented in the court. However, at this time, Russia does not have a judge holding a seat. And in 2018, the UK actually lost its seat. So currently, in terms of permanent members, only China, the United States, Britain, and France have a representation on the court. So the voting system of election to the court, you may know this, it's a nomination system based on nominees put forth by something called the Permanent Court of Arbitration that is then put to the Security Council of the UN for an initial review. After that gets passed, it then goes to the General Assembly. So there's a two-tiered system of elections, and there's a history behind that. The court sits in that building, which is called the Peace Palace. It's located in The Hague in the Netherlands. It also houses the Permanent Court of Arbitration and the Hague Academy of International Law. It was built by a gift from Andrew Carnegie, the tycoon of his day, not the tech tycoons of today, but in those days, steel tycoon. And so he gave this money because he believed in this cause of peace and peaceful settlement. So he gave a handsome endowment, which still finances this building. So the Carnegie Foundation remains the owner and manager of the Peace Palace. And for any of you who may have spent time in the United States, you may know that Carnegie was also a great believer in libraries. He thought access to books, public libraries, was extremely important. So one of the terms of his gift was that there be a library in this building, and there is actually one of the best collections of international law materials located not now all in that building. They actually have an annex building to go with it, but in part because he was a great believer in books and libraries. Okay, so that's the court today. That's roughly the makeup. That's how we get there. That's where they sit. So let's go back in time. So this man here is Elihu Root. He was the Secretary of State of the United States at the time. Great believer in the idea of courts, international courts. You may find that a little odd, given U.S. track record having to do with international courts, but there's a reason why he was a believer in courts. And he actually instructed the American delegation going to the Second Hague Peace Conference. So the Second Hague Peace Conference was in 1907, right? We had the first Hague Peace Conference in 1899. That is probably the more famous of the two. But in 1907, Root instructed the U.S. delegation going to the conference that you must have as the highest priority, you must have one of the highest priorities, the establishment of a permanent international court. A permanent international court, so it would be a court of general jurisdiction with judges who would be judges, professional judges, who would sit in a location and basically hear disputes. Now, his interest in this was not so much in dispute settlement, although that was part of it. It was more in a mode of dispute settlement that would not come near the United States. He wanted to keep disputes as far away from the United States as possible. So there is still a commonality today. The U.S. likes to insulate itself from whatever is going on outside of the country, right? So why did he choose courts? He chose courts because he took lessons from the United States. This is a picture of the Supreme Court of the United States at the time, those white men on the far side there, and that's a building, a Supreme Court building. He really believed that the Supreme Court was a very important institution within the United States to help resolve issues and to basically create a civilized society that could operate. So he thought something like this. If you had professional judges in a permanent location, basically interpreting and carrying out a body of law, you could accomplish something similar. Okay? This was a particular legal tradition of the time in the United States. It goes by the name of legal classicism, which basically believed in legal institutions, these ideas of rule by law rather than by men, things of this nature. And Root was very much an exemplar of that school of thinking. And interestingly enough, all the secretaries of state of the United States from Root on, many were lawyers, and about all of them came from that same kind of legal tradition. So they had a belief in the possibility of institutions to do things in the world that might create a more stable and more settled sort of environment. Okay, so that's just kind of the broad stroke, where did this idea come from? Why was he promoting this at all? It came basically from the U.S. experience, which he thought would be replicable internationally. And indeed, in the Covenant of the League of Nations, there is provision for a court. Article 14 of the League of Nations Covenant actually provides for judicial settlement. But there was no time really to put in all of the details of what this court would look like. So the provision within the covenant is actually fairly broad. It just says that you will adopt plans. The Council of the League, so this was delegated to the Council, will formulate and submit to members of the League plans for the establishment of a court. The court shall be competent to hear and determine any dispute of an international character which the parties submit to it, and they may also give advisory opinions. Okay, this is also important to keep in mind as we go through here. So the League Council, indeed, in its second meeting in 1920, did appoint an advisory committee to basically prepare plans for such a court. The U.S. president by this time, Woodrow Wilson, a Democrat, appointed the Republican. Root was a Republican, Roosevelt was a Republican, so there's a bipartisan character to views of the court, actually throughout these 100 years, both pro and con. So Wilson, a Democrat, appoints the Republican former Secretary of State, Root, to the committee. And he together with the British Lord Fillmore, basically produced what's called the draft scheme that ultimately became the statute of the permanent court. I know in your instructional programs here you emphasize, I think, a great deal teaching of language and competence in language. So this little footnote might be of interest to you, because at this time in the 1920s, the language of diplomacy, the language of international negotiation was French. But Root didn't speak French. And since he was playing such an important role, they had to make many exceptions to allow him to really engage with the proceedings. I mean, obviously he had to have translation before him to take an active part. So the fact that he could play such a dominant role was agreed to by the parties, including in the method of work, which included using English, which at that time was not so commonly used in these kinds of international settings. So they came upon, the usual questions. How do you elect the judges? And they came up with this idea of layering the nomination, which is pretty much the process we have today. You nominate based on these national groups, and then it goes to the council, at that time the Council of the League, for first kind of look over, and then they are elected. So essentially the same thing. Okay, so what was the jurisdiction of the court? So this is the next question. If you have a general court, you have the judges. What are they going to do? What is the law that will be applied, right? Courts need to know that. So the law they're going to apply are international conventions, so that's treaties. So whether general or particular, so it could be multilateral convention or it could be bilateral treaty, as recognized by the disputing states. So as in the case of the United States and Iran, we had a treaty of friendship that said that if we have a dispute, we will take our dispute to the International Court of Justice. So that would be an example of a specific treaty. Or you have a multilateral treaty, which says that in case of dispute, we'll take the dispute to the International Court of Justice. Or you have international custom. Those of you who have studied international law will know what that might be. So this is maybe not codified, but practice that is regarded as law, general principles, and then judicial decisions and teachings. And if you look at the statute of the International Court of Justice, basically this is still the language that is used. Okay, so that's the law that they're going to apply. Then what is it that they're actually going to do, the jurisdiction? Because remember, Root's idea was this would be a court, a general court, not just set up for specific disputes, but actually a permanent court, that's why the name, that would be available to hear different disputes on what? So on interpretation of a treaty, on the questions of international law, on the existence of a breach of an international obligation, or the nature or extent of reparation to be made for a breach. And finally, the interpretation of a judgment passed by a court. So it gives itself pretty full range, right? You determine that there might be a breach, you actually could provide remedy for the breach, and then you, maybe not entirely by yourself, but at least in theory, have the ability to enforce your judgment. Again, pretty much what the ICJ statute says today. Okay, so this is where the permanent court got set up. So let's go back to Root for a moment. What was Root trying to do? Said, this is an expression of U.S. legal classicism, which is, the irony, if you will, since the U.S. has now removed itself from this particular court. But yet, at the time, it was thought to be a really important foreign policy initiative and objective of the U.S., in part because Root felt that this was going to be the best way to contain the violent impulses that he saw. And remember, this is right after World War I, and that the only way that you can contain this is actually to have some kind of structured approach, structured method of resolving disputes. Now, the League Covenant also had Article 10. And President Wilson, Woodrow Wilson, who was in Paris, who represented the United States negotiating the Paris peace, was a great believer in Article 10. Woodrow Wilson actually had no patience for this court stuff. He thought this was really a waste of time. He said, you want to, get sort of organized behavior against aggression and transgression and so forth, you have to have force. And his idea was much more of a collective security kind of approach, and that's why he really believed in Article 10. So that members of the League would have to respect and preserve as against external aggression, territorial integrity, and the political independence of all members of the League. So this was where he felt the effort should be made towards promoting an institution. Root regarded Article 10 as actually the very kind of problem he was trying to avoid by instituting courts. That why you actually have war or conflict, in his view, was that states have no means to resolve these disputes potentially other than go to war. And so he thought Article 10, in fact, was really the wrong direction because it was exactly the kind of thing he wanted to avoid. And in the 1920 election, in which Franklin Roosevelt actually ran as vice president, the joining the League of Nations was a very big part of their platform, including the International Court. But they were not elected, and the United States, of course, never joined the League of Nations, and the United States never actually even joined the Permanent Court of International Justice, although it came very close, and about as close in terms of national policy support for an international court as we've ever had. So let me just take a moment to walk you through that. But following Wilson, we had a succession of Republican administrations, but as I mentioned, all of their secretaries of state actually came from the same kind of legal tradition Root did. So they all actually had a belief that a court would be a good idea and were supportive of it. Okay. Calvin Coolidge becomes president. He was actually the vice president, and he became president when President Harding died. But he decided that this was going to be really a centerpiece of his administration and made this a very important goal that he wanted to achieve. In those days, presidents did not use executive orders the way they do now. Otherwise, perhaps Coolidge could have just signed an executive order. And, as now one departs, one could join with these executive orders. But at that time, executive orders were not quite as used as they seem to be today. In any event, Coolidge asks for Senate approval of the Permanent Court. So, okay, the president wants it. In our U.S. system, as a treaty obligation, this has to go to the Senate for advise and consent. So Coolidge says, Senate, please help me join the PCIJ. The provisions of the court were such that you don't have to be a member of the league in order to be a member of the court. And so that was fine because it was clear the U.S. wasn't going to join the league, but nevertheless, had an interest in the court. So it went to a vote in Congress in 1925, 302 to 28 to join, 302 to 28, and approved by 2/3 of the Senate, 76 to 17. You don't see votes like that these days on virtually anything, never mind an international court. But that approval included 5 reservations, okay? And for those of you who know about treaties and international law, one can, up to a point, take out, attach reservations to your acceptance of any international obligation. So the reservations were that adhering to the PCIG's protocol would not indicate any relationship with the League of Nations, because they wanted to be clear. This doesn't mean we are kind of, backdoor into the League. This is separate from the League. So that was number 1. Number 2, that the U.S. would participate in the election of PCIJ judges. Okay, so that's logical. That the U.S. would pay the court's expenses as determined by the U.S. Congress, which again in our constitutional system also makes sense because Congress holds the power of the purse. And the 4th amendment was, the 4th reservation was that the statute would not be amended without U.S. consent, which would have been the case anyway, because if you wanted to amend it, you would have to amend it with the consent of all the parties at the time. But they wanted that additional guarantee. But there was a 5th reservation that was placed by the Senate, and that's what caused the United States not to be able to join the PCIJ, which had to do with advisory opinions. Now, I don't know how deeply many of you know sort of legal traditions and legal practice, but in the common law tradition, it is less common to use advisory opinions. In civil law traditions, it is more common. In common law, generally, you have to have an actual legal matter with actual parties involved with an actual interest in the matter before you can go to court. You don't ask hypothetical questions. But in a civil law country, you actually could ask, based on certain application of law, would this be legal or not? This is not a practice that's widely used in common law systems. So already it was something that was a little different from what we might be used to in terms of seeing a court, we being the United States. But the other problem was that because of how open-ended potentially that would be, the Senate was concerned that it could drag the United States into political disputes that it did not wish to be dragged into. So that is always in the background, because the idea of even desiring to set up a court was to create sort of an insulation from being directly dragged into a dispute, hoping that an institution would shield it from, more involvement than otherwise required. So the 5th reservation said that advisory opinions could not be taken by the court unless the U.S. explicitly agreed to them if any U.S. interests were involved, which pretty much gave it an absolute veto. Effectively, in the league system, the council had to approve requests for advisory opinions. So effectively, members of the council did hold such veto. The U.S. was not in the league and therefore wanted the veto, but nevertheless, it seemed to be just pushing things too far, so it was not accepted, and the U.S. Never joined the PCIJ. But if you're curious and you take a look at what the permanent court took on as advisory opinions soon after its creation, you could see that maybe the concern was not totally without ground. Because what were the questions being asked? The questions being asked had to do with interpretation of the treaties that comprised the Paris Peace treaties that ended World War I. So this included, what these boundaries really meant. In Australia, And then, probably, towards the end, even the to do with the customs union between, Germany and Austria. So indeed, it did engage of the type that concerned the U.S. So okay, Root is still in the background, but didn't join the League, didn't join the PCIJ. We come now to the United Nations. The U.S. was a little more deliberate in terms of its approach towards the United Nations. It had a whole planning conference going on in Dumbarton Oaks. And for Roosevelt, Franklin Roosevelt, it was very important that the U.S. actually be part of the United Nations. And so all kinds of thinking was put into how to make that so. One of the major ways that he felt it important to make that so was to have bipartisan support. Because what happened with Wilson was that he did not have bipartisan support and did not take the trouble, make the effort to reach out to those across the aisle, as we would say, Republicans, actually to gain support for the League Covenant. And so, with the results that we know. But Roosevelt had a different view and very much wanted to be sure there was bipartisan support. So Republicans were involved in the conferences, in the discussions, and so forth. And we also have an important participation by somebody who's, if you look at the signature page here, that's the U.S. delegation. There's a very long signature that's you cannot probably see very well, but it is the name of Arthur Vandenberg. Arthur Vandenberg was the senator from Michigan, who was the ranking member of the Senate Foreign Relations Committee. So it was important that he be on board, and he was on the delegation. In fact, he was part of the U.S. delegation signing the UN Charter. Now, Vandenberg was not, he was a little skeptical. He was a little concerned about international institutions. He was concerned about them somewhat, the nature of the international institution, but more because he was concerned that it would give the president potentially too much power, that it might, in fact, step on the prerogatives of Congress and the Senate to do its part in matters of declaring war and international affairs. And if you've read the U.S. Constitution or had occasion to look at it, you see that there are some responsibilities that are given. But it is the sort of more open-ended powers are given to the executive. But nonetheless, so Vandenberg said, I'm a little worried that if we go with the UN the way it is, it may give the president too much power. But he's thinking through this, and over time, he decides that American interest actually requires that we be active participants in international institutions. So he says, I want maximum American cooperation consistent with American self-interest with constitutional process. So he's a senator. He wants to be sure Congress has its role to play to make the basic idea of Dumbarton Oaks succeed. And so he says, for these reasons, and not only did he vote for it, but more importantly, he got his Republican fellow senators to vote for it. There was a big conference held at this Mackinac Island in Michigan. He took them all there. It was a nice little resort area, and basically told them why they needed to actually support the UN and the International Court of Justice. Now, the ICJ statute is part of the UN Charter, and all members of the UN, in fact, are members of the International Court. So because now you already had the court established, you didn't have to take the time to set it up. You could just adopt it. But the jurisdiction of the court, each state still has to make its own decisions. So we have 193 members of the UN right now, and there are a substantial number of countries that have not accepted actually the wide compulsory jurisdiction. It's actually under 100 or so. and the U.S., of course, and increasingly there are states that are even beginning to withdraw their acceptance of this. But that's jumping a little bit ahead. Now, even though we did accept the jurisdiction of the court, we did so with reservation. And this reservation is pretty open-ended. It basically says that we accept the jurisdiction of the court only as long as it does not touch on any matter dealing with that is regarded to be within the domestic jurisdiction of the United States, as determined by the United States. So that was thought to be adequate protection at the time. So as of October 2019, there were 74 acceptances of the ICJ's compulsory jurisdiction out of 193. Remember, the goal was you would have a general court that would be available with advanced acceptance of jurisdiction of that court by member states, specified disputes, that was the category of disputes, with the law that they were going to apply. So that was the idea of the permanence of this, with professional judges ready to hear disputes if it fell in those different categories. So we only have 74 acceptances, and everyone's got reservations. In fact, of those 74, only 11 have no reservations. Of the 5 permanent members of the Security Council, the United Kingdom is today the only one that accepts the court's compulsory jurisdiction, and it has sizable reservations, quite similar, in fact, to the U.S. And the U.S. has slowly withdrawn from the jurisdiction of the court, but so have some other countries, Israel, El Salvador, and Colombia among them. And I dare say I think the list is growing these days. So this is not at all something that is settled. Okay. Just very briefly, and then we can kind of have a conversation and see where you want to go with this. So what has the ICJ been doing? Has it, in fact, realized its promise at all of being an alternative mode of settling disputes? So again, these numbers are from 2019. There were 148 contentious cases. So contentious cases are cases where there's a V. So Iran v. U.S. Or Nicaragua v. U.S. or U.S. v. Bulgaria, something like that. Those are contentious cases. Who has been sued? Out of the UN's 193 members, 103 of those have been either a plaintiff taking somebody to court or a respondent being sued, including 27 from Africa, 31 from Europe, 15 from Central and South America, and 8 Asian countries. China is the only permanent member of the Security Council never to have appeared before the ICJ, although it has a very active judge. U.S. and the United Kingdom have had the largest ICJ appearances, with 25 against the U.S. or the U.S. suing somebody, and 14 in the case of the U.K. The bases for these cases have been either specific treaty provisions, again, that U.S.-Iran treaty would be an example of a specific one, or something by special agreement. You can also just say, we will make an agreement to take a dispute to the International Court, or you can by international treaty, if it provides for dispute settlement by the court, you can do so. And one of those treaties is actually the the Vienna Conventions on Diplomatic and Consular Protections. And this was, in fact, used by the United States suing Iran after Iran took hostages at the U.S. Embassy in Tehran. So the U.S. sued Iran on the basis of the protocol that provided for compulsory settlement of disputes under the terms of the Vienna Convention on Diplomatic Relations of 1961. And the U.S., for all intents and purposes, won that case. So if one is concerned about politicization and, does this have any benefit to U.S. interests? Well, actually, the U.S. doesn't have a bad track record. Doesn't have a perfect track record, but doesn't have a bad track record. But unfortunately, the court got into some things that sort of hit very close to U.S. internal operations. and so made it a little bit more of a target for kind of negative thinking. And this had to do particularly with a series of death penalty cases that also grew out of the consular conventions, because in the United States, we still have the practice of capital punishment, not in all states of our 50 states, but in some. And in some cases, individuals who were found guilty of crimes that would merit, in the terms of that state law, the death penalty, some were actually found to be foreign nationals after they went through the whole trial proceedings. So the countries from which these individuals come, Mexico and Paraguay were two, Germany was another, in fact, said, United States, you actually have violated your obligations to us, not necessarily to the individual, because this is, state-to-state treaty. The consular protection is actually a state-to-state treaty to protect our nationals. You have failed in your obligations to do so. Therefore, you must do something to remedy. Now, the court, understanding it's an international court, cannot tell sub-national jurisdictions within another country what to do. So it's so that you, United States, choose the means to remedy this, but you need to provide some remedy. So the State Department, U.S. State Department, did communicate with these states to say this has occurred and, at least pause your proceeding. And in some cases they did. And in one or two cases they actually did not execute the people. In other cases, basically, the state officials said, ICJ, Hague, what is that? And no. We have obligations to our own people, to our own criminal justice system, and whatever the problem is, that is for you in Washington, D.C. to deal with. We sitting in the capitals of Virginia or Arizona or Texas basically, aren't going to pay attention to this. So that's a structural problem, because we are a federal system, and international obligations do not necessarily filter directly down into particularly the subnational areas, unless there is legislation to make it law of that type. There were actually efforts to do so, but for a variety of unexpected reasons, there was opposition to say that at least you should notify people if they might be foreign nationals, that they might be able to have access to consular protection and advice. But I think U.S. law enforcement thought it was too complicated to do that, and so put a lot of political pressure against doing so. Despite that, there are quite a number of states in the U.S., just as an aside, that actually has passed law to say that their law enforcement does actually have to pay attention to the Vienna Convention terms. Okay, so it's a little bit of a mixed, in terms of who won, who didn't win, and so forth. For the United States with the court. But I think the main thing that caused the U.S. to really try to withdraw from this was not so much whether the U.S. won or lost. In some ways, I think the idea is, well, we may not like to lose, but it may not necessarily affect us that much. What we really wanted to do was, by joining, have others join too, and have others take the institution seriously. And this is what is both the unfulfilled promise and I think somewhat the irony. Because in some ways, you're probably sitting there thinking, of all countries, it is the U.S. who seems to take these least seriously. And indeed, that is true. If you try to lead by example, and this is your example, well, then you're not sending a very good signal. And yet, it is that disappointment in terms of the use of the institution and the politicization of the institution that caused the United States to ultimately withdraw pretty much completely now from the International Court. Don't be surprised, however, if you do see the U.S. appear in The Hague in that grand building at some point, because there's always the possibility of special agreement, which we might do from time to time and still go before the court. But nevertheless, the idea that you would have a widely accepted body, widely respected, trying to adjudicate matters of some sensitivity to countries, at least in the view of the U.S., was not, the expectations it had was not met, and therefore it felt that its exposure then to being, told, you're breaking the law and whatnot, was too high a price to pay. And as these things develop, starting in the 1980s under President Reagan's administration, of course, within international law circles in the United States, there was a lot of discussion about whether this was the case or not. But you could already see the direction in some ways of the International Court of Justice in terms of the kinds of cases it was taking up, the kinds of issues it would be addressing, that would not necessarily be ones the United States would find squarely within its own interests. And so, that very concern starting way back in 1920, whatever, about advisory opinions, maybe going into areas that the United States would not want to be dragged into, is very much a possibility based on what the International Court does. So that's the US side. But the problem is the world actually has moved on. And while no country necessarily likes to lose, I'm sure, still, we see the proliferation of international courts. We see varying degrees of acceptance of jurisdiction of international courts. In fact, courts subsequent to the ICJ now have been set up with more specific responsibilities, and in fact with jurisdiction that is compulsory from the beginning. It's not an opt-in situation now. You pretty much have to accept it. And we have, I think more than 100 international courts and tribunals functioning in the world today. So there is a culture of sort of working with judicial institutions around the world. And, the United States is sort of an outlier in this regard in terms of taking part in any way in something which is very, held dear by most Americans, certainly most American lawyers. We think our judicial system is pretty good, that it has a great deal to offer, a lot of the world by way of example. Including possible replication at the international level for settlement of disputes. But yet, in operation, in practice, we have had this, it's not even a love-hate relationship. We never got to the love point, I think. It was always just kind of ambiguous relationship to outright hostility to the institution, which I think is unfortunate because it is a place where U.S. started out showing leadership, and then basically has, I think, kind of abdicated it through its actions. Anyway, so I think I'll just end there. I hope I give you a little bit of a flavor of the ins and outs of these things. You need somebody who's in a position of influence to advance something. You can get pretty far to get those political forces together. There's always domestic politics at play. One needs to be mindful of that as well. And sometimes I think at the international level, at the international institutions level, we are not necessarily so cognizant of that. And it then creates fertile environment for making rumors and false information and lots of the kind of pushback. These kinds of institutions, judicial processes, necessarily slow. You try to hear all sides of issues, and sometimes when you are feeling deeply grieved by something, you just don't want to sit through all of that and somehow feel you're being disadvantaged. So it is unfortunate that we have come to this moment, but there's always another day. Thank you.
Thank you very much. So those were 100 years now of evolution of international courts up to the ICJ, focusing on the United States. And now feel free to ask questions, whatever comes to your mind. And if you want to push a little bit beyond, perhaps into the here and now, or ask about different kinds of states or whatever, I think that would be fine with Charlotte as well. And then maybe because you're in the back, let's just start in the back. Let's make it easy for you. Yeah.
Good evening. Thank you very much, Professor Ku, for this interesting lecture and walking us through those times. I hope that you don't mind that two of my questions will be related more to today's agenda. So when it comes to the U.S. particularly, we see that the attempts to legitimize the achievement of peace and justice through force nowadays. So what, in your opinion, should be the position of the court? Should it be justification? Should it be support, acceptance, or resistance, maybe? And the second question is, from the point of view of the International Court, does it maybe need additional powers and competences or expansion of jurisdiction, perhaps, in the context of general decline in the authority of the United Nations right now, specifically for the strengthening of this authority? Thank you.
Thank you, Veronica. And if it's okay with you, I'm just going to bundle. So I'm going to have two more and just take whoever's next to you, then make it easy for you.
Hello. Professor Ku, could you tell me if President Trump decides to leave the ICJ, would that be possible with an executive order?
Okay.
Thank you. And then, yes, in the middle. Yeah.
Thank you for being here with us tonight. My name is Thomas. I'm a student here at the Academy. I was wondering, you mentioned that in the US there is a structural problem with federal and state law when it comes to the application of international law, and in particular these ICJ cases. Do you anticipate or have you observed any momentum of states to emancipate themselves from, let's say, from the federal level? Or do you think this could happen in the future, given that now there are a lot of forces that drive opinions apart, I guess?
All right, right. Okay.
Thank you, Charlotte.
Yes?
Yes.
Okay. So on the structural problem, indeed, states are trying to assert their own authorities to bar federal actions, and they have certain powers, and in some cases they have been really allowed to exert those powers. So I think it's something that we have to wait to see how far one can go with regard to standing alone. If you're a large state like California, you have more ability to do so than if you're a small state. So this waits to be seen. Sadly, many of you may, of course, know this. This is not a debate that the U.S. is having the first time. And we had this debate over slavery in the 1860s. And indeed, states did decide they were going to leave the Union because they did not agree with the positions of the federal government. And we actually had a war over this. So this kind of structural problem and the level of pushback states can render against federal authority, there will be things to be seen. I think what the best case scenario, so let's, if we can be optimistic for a few moments, is that it may clarify where the boundaries are and where there's shared authorities and where everyone can sort of do their part. Part of the theory behind our federal system is that the states are laboratories of democracy because they are closer to the people and therefore they express more the popular will, which is not a view that is not shared, in fact, by the Trump administration. In certain matters, they think, these things should be with states. So it sort of depends on the issue. But how do you pick and choose the issue and then pick and choose the jurisdiction? You would have a very kind of crazy Swiss cheese if you're in the United States with regard to what is the law here and what is the law there, right? And that's the very reason why we have a federal government. But yes, no, there's a lot of work being done on that. But what is the long-term result? I think it's at best something that calls attention to a problem, hopefully creates a pause, which is supposed to be one of the virtues of dispute resolution, to think through what the policy should be, and then you move from there. But I think it's necessarily limited what a state can do, even a big state can do by itself. So you can only go so far. So there's some practical limitations, putting aside the legal ones. With regard to if Trump decides to leave the ICJ, well, Trump has effectively already taken the United States out of the ICJ because, once you've basically declined all of the jurisdictional coverages of the court, you cannot be sued before the court. So, you're a member of the UN and therefore, by virtue of that, a member of the court. But you don't, in fact, accept its jurisdiction. So effectively, we are really not actively part of that court system at this time. Let's see, the first couple of questions. I'm afraid I kind of forgot what it is.
Veronica,
do you remember?
Do you wanna very briefly? Yeah.
The first one was about the U.S. So basically, we see that there are attempts to legitimize the achievement of peace and justice through force. So what should be the reaction, basically, of the court? And the second question was regarding the United Nations, specifically from the point of view of the court. Does it maybe need some additional powers, jurisdiction in the context of declining of the UN?
So the interesting thing with regard to using the court to legitimize actions or delegitimize actions, yes, of course, this occurs. The interesting thing is that if you look at the court decisions, they can lead to settlements. They just may not be themselves the settlement. So even in the U.S.-Iran case, so Iran was not interested in hearing from the United States about its violation of consular and diplomatic law, but nevertheless it negotiated a settlement, which freed the hostages, the U.S. hostages, and set up the U.S.-Iran Claims Tribunal that sat in The Hague, so that the money that was frozen as a result of the conflict could be dispensed based on certain claims that would be brought to this claims tribunal. So there was a negotiated settlement. In the Nicaragua case, U.S. walked out of the court, said, we don't want to hear from you about this. The court rendered judgment. Okay, end of story. Not quite so much end of story, because when Nicaragua decided it actually may want to reestablish diplomatic relations with the United States, they undertook a negotiation. And the starting point was actually, where the court was. And in fact, came up with something which, was face-saving, but Nicaragua basically pulled its case back and said, okay, we're taking care of this matter ourselves, and we're not going to move it forward. But in the meantime, you are providing some clarity with regard to what the legal standards of the moment might be. So there is, now that we've had this history of the court and jurisprudence to look at, you can see where the court's judgments can give you some understanding of the development of that particular law at that point in time. And that may be a stepping stone then to a settlement for the specific dispute, but it actually also contributes to the broader legal understanding of whatever principle is being brought to bear. And now that we have other courts, you even can compare judgments, and sometimes they are in conflict with each other, but still, it gives you an opportunity to gain some clarity with regard to what standards would apply on things like use of force or self-defense, things of this nature. Strengthening of the court. The court actually is busier than ever at a time when you would think the political environment is not really conducive to, to bringing disputes to a court, or as you say, maybe, the UN is not necessarily thought of as being, the first place one might go. But in fact, many interesting issues are being brought there because it.
Sorry, I meant the strengthening of the UN. I meant the strengthening of the UN.
By the court.
By the court.
Okay. Well, the court actually in its early days did things to strengthen the UN quite a lot by, first of all, acknowledging that it would have some form of legal personality, which was actually left a little ambiguous in the UN Charter, that the UN would be charged with doing things which might put it in harm's way, which meant that it has to have a certain power to protect those being sent out on its missions. It allowed for operations to run and acknowledged that judgments of things like administrative tribunals would be acknowledged and honored by the agencies that hire people to work within the UN system. So in that respect, it functions like a constitutional court, which says, which organ is doing what and how well is it doing. So could it strengthen some? It could, but I think the court is also cognizant of being realistic about what it's going to prescribe, because it does not want to degrade its value and so forth. So it tries to be careful. And this actually goes even to how judges behave. So you have 15 judges representing different countries. They, you have the permanent 5. Maybe now just the permanent 4 since the UK doesn't have a seat. The other 10 spaces, or 11 spaces, are taken up by the different regional groups. So you have an international representation, and then if you have a dispute, you can actually appoint a judge of your choosing. It doesn't have to be of your nationality, of your choosing, to sort of represent your interests on the court. So the question is, so isn't there natural bias by these judges towards one or another side? Only up to a point. And there seems to be some evidence that suggests that, these are lawyers, and so they will look at the point of law, and it is the law that they seem to be most interested in understanding, clarifying, and developing, in part because I think that's where they think they probably can offer the most value. So this could go towards even steps that, have the result of strengthening the UN. You see those more in the earlier days when questions of that nature came up. They tend to not go into too many of the political questions, although if you look at some of their advisory opinions right now, you'd say, well, they are hardly shy about taking up questions. So, and the UN itself, of course, by asking questions to the ICJ, seeking advisory opinion, could in fact be saying, would you give us a little signal here as to whether we could, maybe move people along a little bit more? There is this kind of strategizing. In fact, the advisory opinion side is sometimes called soft litigation because it's not the versus, but you actually have parties and you kind of know who you're who you're aiming your issue at. But it's not versus, so it's not quite as adversarial. And so it's thought to be soft, but nonetheless you're framing the issue. So in this respect, you could also be strengthening the institution for action.
Thank you, and I'm going to move on to the next one. Yes.
Hello, my name is Pablo. Thank you for your presentation and for your detailed guidance. For your detailed guidance regarding the U.S. attitude toward the International Court of Justice, but I also want to touch upon the structural problems, which you mentioned. It also was referenced by Thomas, especially as you said that there is this idea that the federal system is not really, let's say the states don't really comply with the approach at the federal level. But what seems to me is the structural problem actually is that there is this lack of, let's say, culture of respect of the, let's say, international law in general among the politicians, because all the actions of the US are guided by the idea of sovereignty and the supremacy of national interests. And this leads to this pragmatic approach of application of international law. We see again, like ICJ is one of just examples. We know the ICC, we know WTO, we know like approach to human rights, Inter-American Court of Human Rights. So, and another factor is that it doesn't really, in fact, whether the government is Republican or Democratic, because we see that, of course, Trump is ready to take more resolute and radical actions, while Biden administration didn't really contribute a lot as well. We see that the sanctions, not the sanctions, the statements regarding ICC persecution of arrest warrants with regard to Israel, Netanyahu, and then we see that, again, like WTO appellate body is still blocked. So my question is that maybe it's the right approach is to start to work with the culture of like considering international law as the regulator of international system rather than, let's say, the guidance by national interest and sovereignty? And do you even think that it's feasible to work in this direction in the US context? Thank you.
Thank you. And then maybe hand it over straight away.
Thank you. My name's Jacob. I'm also a student here. You mentioned that almost a century ago, many in Congress, including Chairman Connolly, were worried that joining these organizations would give Article 1 power of Congress to the president. Given the antics of the last few years and last few weeks, do you think that was prescient and even more the case now?
Thank you. And then one more in this batch. Yes.
Good evening. My name is Nico, also a student here at the institution. Anyway, my question is in regard to the US's insulation and its like sort of maybe the realist perspective of power and national interest above all else. Is there any way to reconcile this notion with the notion of institutionalism and strengthening, I'd say, or not just strengthening, but actively participating in a rules-based international system? Because if not, at least I'm under the impression like the international system as we have it right now might deteriorate into sort of a, I'd say, maybe a system of minor states while the great powers remain on the offside playing the more opportunistic role in a very selective approach to.
I mean, actually three of your questions touch on something which is related, which has to do with internalization of the idea of international law. Internalization, I mean, within the U.S. Mind, within U.S. political culture, within U.S. political thinking. The challenge with that is because the United States is big, because there are many political issues, because of the way we run our elections and things like that. It's very difficult sometimes for issues of international institutions, international law to rise to the top of debates, other than in a negative manner. Negative manner, it's easy to sort of poke at that as being kind of an enemy. But to sort of discuss the benefits, they could be long-term. Yet we know how to play for the long term. When we set up the entire international trading system, we were prepared to lose in the GATT and the WTO and all of that because we thought the rules were more important to have in place than the winning or losing. So it's not as if one cannot do that. The problem is that thinking, that desire, even something like Vandenberg's thinking, somehow doesn't seem to be able to move on beyond that person, or doesn't go very deep beyond that person. Now, is it because we have poor education, because socialization is bad? Perhaps all of these things. But somehow that commitment, that desire to feel these things are important, doesn't seem to go beyond maybe a 50, 70-year-old time span, which is what we're looking at right now, because people just don't seem to really remember and understand. With regard to the Article 1 powers, it requires Congress to actually push back. They're there. They are on paper in the Constitution. But unless the people sitting in those seats in this Congress wish to use that power the way Vandenberg was prepared to use the power by blocking even actions by the president, then it's not going to happen. The expansion of executive power, and this predates Trump. It actually goes back, much further, probably to Franklin Roosevelt. Has to do with the fact that Congress allowed it to happen, sometimes even delegated it. And once you give it away, it's quite difficult to pull it back. And you see that even though Democrats and Republican presidents will use the executive power for different purposes, when it's just the abstract concept of could the executive have the authority to act in this manner, they are not so different in their thinking. So there definitely has been a great expansion of executive power, although I must say, I think until recently, no one has been quite so bold as to say, the president is supreme bar none. because that is certainly not the way the Constitution was written. But even if you don't say that, unless your co-equal branch of government, and particularly the Congress, is prepared to actually exercise that authority, then the authority is not going to be exercised, and the one who does exercise will prevail. Active participation. This is, again, it's socialization, it's internalization, it's leadership that says these things are important, and this is why it's important, and this is why it's important for you. And somehow we just don't seem to have those kinds of conversations very much in the United States. Even, the perception of international aid that the U.S. provides, it is a small percentage of what the U.S. spends. And, all of a sudden it's become, this huge target. And, if you look at these Pew Research studies and all of that, over and over again, they show that Americans think, oh, we give 25% of our GDP to foreign aid. I mean, not even close in the single digits. So, so it's information, it's the socialization to think that, we need to be good neighbors, we need to be good friends, because after all, it is also to our advantage. That is just not somehow a message that gets transmitted. Because institutions are only as good as the people who are in the institutions, including citizens. If they're not prepared to, make their voices heard, then, it's the voice that's the loudest is the one that will be heard. So this is what we're wrestling with right now. And, we don't generally take the time to, look at other enterprises like Europe, that have also had stumbling blocks trying to create a union, right? But still, there seems to be, a push to keep going. So so it requires leadership. It requires internalization. It requires a certain socialization, and cultural awareness, which we just don't generally have in the States, because it's too easy to focus on so many other things. Even in my law school, if I digress for just one quick second, most of our law students, we're not required to take international law, do not take international law, have no idea actually that international law may exist. So one way to elicit their interest that I've worked on is to create what we call field courses, to take them to jurisdictions to look at issues, because law students in the States are interested in building a good professional dossier. And so to say you've done something interesting in a jurisdiction, well, it accomplishes many purposes, because immediately when the student steps out of the United States, and you don't have to go very far at all, you immediately hear about human rights and international treaties and the inter-American system and all of these kinds of things. And students are, their eyes are, and these are their contemporaries, and they've never heard of these things. And then they, oh my goodness, why don't we hear about these things? And then they talk about it. So at least introduces the idea that these things exist and they could actually have impact and do have impact on their clients' lives. So when they come back, of course, then they are interested, and then they can see, but this might affect that, or this might affect the other, even if we never leave the United States. Because family matters may cross borders, or you may represent corporate clients that may cross borders, or whatever. I mean, what is not going to be crossing a border these days, for the most part, with regard to legal practice? So, but it's just not thought. It's thought to be optional, because other things are more important to teach. Other things are more important to debate. Other things are more important to discuss. So if you don't take the time to do it, why would anyone know about it, right? So.
Let's do one last round, a very quick one of questions. There's one more hand up there. Yes.
Hello, good evening. My name is Karen Parraga. Thank you for this interesting presentation. I think I have a concrete question. Is in cases where the ICA applies bilateral or multilateral treaties as sources of law, like you mentioned, how does the U.S. Balance its treaty obligations with its reservations to the court's jurisdictions? Like they could have, because there has to be a way to solve international disputes and be reliable to other states. Mm-hmm.
Thank you. And then in the front. Yes.
Thank you for a very interesting presentation, Professor Kur. My name is Lubomir Sokolievski, doctoral researcher at the University of Vienna. I have two questions. At the beginning, you started your presentation with some history of how the ICJ, the PCIJ and then the ICJ was set up, and you mentioned the sources of law. I wanted to ask you, do you have any information on why paragraph 2 of Article 38 of the ICJ statute was included? Because to my knowledge, it hasn't been used. And the second question is, do you think there is still appetite in the international community to towards creating other specialized judicial bodies? Thank you.
Okay.
Thank you. And we would have one more spot if someone wants to. That's okay. Then
Let's not waste it.
okay.
Thank you very much. Very interesting for international relations people who are not lawyers. So you mentioned, Charlotte, this dispute between the US and Iran over the hostage taking, I guess under President Carter. Were there other cases that involved the US over the history, and how were they settled, or was that the only one? I mean, I'm interested. It's a tool used by many states. I think also by the United States. Were there other ones that were ruled in favor of the US so that the benefit of the rule of law became clear?
Mm-hmm. Mm-hmm. So let me just take that one up. Iran and the United States have actually been in front of the ICJ many times. The U.S. Military naval forces accidentally destroyed some oil platforms of Iran's at one point, so Iran sued. And the U.S. Took a look at this and determined that, actually, sorry, must be jet lag. I think I've got the wrong case there. But in any case, one of these cases, the U.S. actually was in the wrong and admitted it. And paid damages and so forth and so on. So when it's a clear case of something, they will do it. And there have been some victories. The hostages one is the biggest one, but I will have to think about where there have been some others. So the question is, when you're in a court, in a court in the United States, the root was so enamored of judicial process and the Supreme Court, it's part of the Constitution. It's a given. When you join the United States, that's part of what you're joining. You don't say, oh, now I'm going to opt out of, the court. So basically, it's a long-term commitment. Yes, you win, you lose, but it's still the commitment to the institution. And that's where somehow in the ICJ, it seemed to be somewhat different. So on the sources of law, custom. Equity. Equity is used rarely, but it has been used if needed. So, the judges will apply what they need in order to come to a resolution. I think the approach would be to apply the most settled law and where you have the vastest amount of settled law before you start reaching into principles that may not be so universally understood. So when you apply them, you would apply them very carefully. You would spell it out in great detail so that those who don't understand what settlement on equity or principle like estoppel or some other common law type of thing would understand why that's relevant. Because at the end of the day, the court, through its judgments, is not trying to necessarily make law, but it's actually trying to add to the body of legal tools that it, for one, can use at some other point, not against the same parties, but maybe at some other time. And other courts will see, that this can be used. So, there would be, I think there's definitely possibility for using these things, and it may even expand with regard to indigenous or customary practices that may apply to certain areas. A colleague of mine actually appeared before the court on a matter between Bolivia and Chile over an international waterway. And the part that he was arguing was that the river that Chile claimed was the Silala River that Chile claimed was an international waterway, was actually part of the ecosystem that was very much part of the traditional culture of this particular indigenous population of Bolivia. And therefore, even though the rules of international waterways would apply, that there are other things that Chile needed to keep in mind in order to respect the traditions of, because to have rendered this body of water, one way or another would have made it impossible for this population to have lived. Now, that was not a point that necessarily prevailed, but it was one that the court took note of. So you can also, expand depending on the circumstances in terms of what you're going to apply. Will there be more international tribunals? I think so. There's been a tremendous proliferation of what they are. The U.S. does not have a total allergy to international proceedings. We were happy with having specific ones in the matter of international crime, but as determined by the Security Council. So you would set the terms, you would set the tribunal, you would set the rules of the tribunal, and then you do that. Or even with the ICC, not completely against referring individuals to the ICC, but again, the Security Council doing that, not based on independent investigations. So we are a bit ambiguous about that. Bilateral treaties. Bilateral treaties, you can set up your own system of dispute resolution. You can set up as a system, or you can set up as ad hoc. So, in any sovereign relation between sovereign states, you sort of set the terms of how you're going to be held to account, and then how potentially remedy will be extracted. How are you going to determine whether there's a problem, what the issue is, and then potentially the remedy. So those can be set out in advance in a treaty, in some treaty term, or you can make it specific. And then there are various methods. You don't have to go before a court. You can go to arbitration, you can go to mediation, you can just negotiate. You can just set the terms for a negotiation. Or even if you go to a court, you may negotiate in advance and go to the court. One of the legacy issues left over after the U.S. Revolution between the U.S. and Canada had to do with the Gulf of Maine, this big body of water between Canada and the United States. So when the peace commissioners from the United States went to meet the British in Paris to sign the Treaty of Paris, which finally gave the United States its independence, they said, this is too complicated to resolve. We cannot deal with it. And at that time, the UK was in charge of Canada, so that was it. But in the 1980s, so not until the 1980s, did Canada and the United States finally decide that they were actually going to go to arbitration to determine and delimit the boundary between the Gulf of Maine, mostly because a lot of fishery resources there. So that was done, very intricate arbitration, but they couldn't agree on lobster. So this regulates, fish that swim. There's a more scientific definition of that, but not the ones that walk. The items that walk are not yet covered. So to be, so you see, even within such old treaty realms, you still set up conditions for settlement. The last thing I will say is just on the political front. Franklin Roosevelt, and probably until the Vietnam War, there was a strong sense that foreign policy should be something that is a bipartisan enterprise, Democrat or Republican. That I think somebody used to say that your differences end at the water's edge. So when you come to the coast of the U.S., when you go outside of the U.S., you should be as one. You should not have these differences. And you have, a bipartisan foreign policy. But this has fallen apart, and I think that's part of the difficulty as well, because you don't undertake that internal negotiation to clarify the issues and understand what it is you need to do in order to maintain something which you presumably have some collective interest in, as Vandenberg did. He had very strong views that said, I actually did not support going into the League of Nations because I think the U.S. should be careful about what it gets drawn into. But yet I feel that international institutions and international law in today's day, 1946, is important enough that I have to overcome my concern. But that I, as a senator, will then be watchful. You see, this is how it should be. You kind of get the international and then you discharge your obligation internally. But we just don't seem to get to all parts of those conversations these days. So anyway, yeah, it's not the happiest story, not the happiest place to be. For all the work that has gone into these institutions, all of the tremendous thinking and so forth, how easy it is to tear down and destroy. But I think we should at least take heart that these things don't go away forever. Maybe at the moment they are not so actively or present. But there are many who, for the first time in the United States, have to think about these things now because of some of the actions that are being taken. Should this conversation been had under better circumstances with better framings? Probably so. But nonetheless, they didn't occur. And so now we are where we are. And so hopefully there'll be opportunity for some better thinking about where we should be going and how we engage with the world. So,
Charlotte, on that note, because I think that's a very good note to end. Thank you very, very much. She arrived just today from the US, so I think she was very, very brave answering all our questions. And thanks a lot to you as a very active audience, and have a nice evening. Sorry about my coughing fit.